Story 1. I am not an attorney. I worked in a firm. A workers' compensation claim involved a man who fell at work and claimed injuries to his shoulder, knees, and back. We told him to stay off social media. He said he did not use social media. At trial, he told the judge he had been a spin class instructor but could no longer teach after the accident. However, he had continued to teach. Hours of surveillance by the insurance company showed him teaching and vigorously riding in spin class. How did the insurance company know he was still an active instructor? He had posted his full teaching schedule on his Facebook page. His potentially lucrative claim was quickly converted into a fraud allegation against him. Story 2. The client had 9 years added to a short sentence. He had received 1 or 2 years for participating in a drag race in which the other driver crashed and severely injured someone. Toward the end of his short prison term, he attempted to escape and was given an additional 9 years. While in a New York prison, he became friends with the man who killed John Lennon. Story 3. The client was being sued and did not like the opposing counsel or the judge. He left the court several voicemails that were so profane he faced a criminal contempt of court hearing. Story 4. A friend of mine used to be a latent print analyst. She was going to take the fingerprints of a suspect arrested for breaking into a house to rob it. While she was setting up the ink and paper, the suspect shouted, "What do you need the fingerprints for?" She looked right at me when I kicked in the door. Story 5. With the utmost certainty in his voice, he yelled at the arresting officer, "It is not domestic violence. I am on public property." You could tell from his face that he really thought he had the police officer over a barrel, but he did not. Story 6. I once had a convicted criminal explain to me why their murder charge should be overturned. The victim did not die at the scene of the crime but at the hospital, so the defendant could not be charged with anything more than attempted murder. Story 7. He was not my client but the petitioner attorney's client. The man claimed workers' compensation and listed nearly half of his body parts in the petition, alleging injury to each. My firm knew the claims were false. We were going to trial, and the day before we ran one more social media search. He had posted a video of himself winning a breakdance competition only a few months after the alleged work incident. I had never seen a quicker dismissal. Story 8. Around 1990, a man was on trial for armed robbery. He pleaded not guilty. A witness on the stand identified him. The defendant jumped to his feet and said, "I should have blown your head off when I had the chance." He paused, then added, "If I had been the one who robbed you." Story 9. I had an instructor who was a prosecutor. He called a witness who had seen the whole thing and had an interest in seeing the defendant punished. It was a slam dunk case. She thought she was on television and overacted every word, embellishing the retelling. She did not lie, but she made herself the center of the story. He said you could see the jury members' faces souring minute by minute. He lost the case. Story 10. I was on a jury when the defendant appeared in court on day 1, wearing the same outfit as the unknown suspect in the crime video. The judge called a recess within seconds. All the lawyers met with the judge and came out about 7 minutes later to announce that the defendant had accepted a plea deal. It was wild. Story 11. I am not a lawyer, but I used to review disability claims, so I often worked with clients who had lawyers. A man whose attorney had instructed him not to speak with us directly, which was a sensible recommendation, called me to rant angrily that his lawyer was wrong. He said he could shop for groceries, mow the lawn, and do all sorts of housework without difficulty. I had seen his medical records, and there was no way he could do all of this without difficulty. I probed further. He could shop for groceries if he used a mobility scooter and had his wife carry items in the house. He could mow the lawn if he used a riding mower and took a lengthy break every 10 minutes or so. His housework was limited to wiping down counters and folding laundry, but not carrying it. I called his attorney and gave the attorney a quick update as soon as we hung up. I approved his claim, but that man was lucky he got someone who was willing to take an extra 15 minutes with him. Story 12. I am not an attorney, but one of our clients baffles me to this day. He had multiple cases, including aggravated battery and drug possession. At the insistence of his family, We moved heaven and earth to obtain a bond so he could get out of jail and live with his family until the cases were resolved. The whole process took weeks. Less than a day after his release, he was caught stealing $16 worth of batteries from Target. His bond was revoked. To be fair, the line between stupidity and compulsion is blurred in this case. For anyone who is curious, we immediately ordered a psychological evaluation for him. He was found competent, but the evaluation confirmed that he had mental health issues. The aggravated battery charge was ultimately dropped, and he accepted a plea for time served. Story 13. Not in the United States. The judge asked whether the defendant was remorseful. Showing remorse can result in leniency. The defendant did not understand the question and usually answered no. Story 14. I have two stories that come to mind. 1. A colleague of mine represented an arsonist many years ago who had allegedly set a large fire that burned public land. Because of the high monetary cost of the damage, it was a felony. During the prosecution's case, the defendant began touching himself in the courtroom, and a recess had to be called. Interestingly, that behavior affected the sentencing phase, since it suggested a mental component, but I do not know if the evidence presented up to that point would have produced a guilty verdict. The second is mine from many years ago. I had negotiated a very favorable deal for a man facing a serious theft charge. Before the plea was entered, he was arrested by the sheriff's office for violating bond conditions. The sheriff alleged he used the sheriff's office banking information to pass fake checks, which made the sheriff's office the victim in the new charge. Needless to say, the deal vanished. Story 15. The client returned to court intoxicated after the luncheon adjournment. He fell asleep. His head dropped against the side of the witness box, and he began to snore loudly. Story 16. My wife's lawyer now bans all clients from using social media after he lost a big case. It was a wrongful death lawsuit. A man's wife had been killed, and it looked like easy money. They were about to settle until the other side found photos of him online from a club a week after his wife died, showing him getting a lap dance and wearing a shirt that said, "I love MILFs." Apparently, they no longer believed he had much pain and suffering. Story 17. The client was part of a group of active pedophiles. One of the others killed the boy while several were involved in physically abusing him. The client's defense was that he was only a voyeur, so although he was present, he was not involved in the murder. He was on bail throughout, including during the trial, until he changed his story and said he had not been there. His sister testified that he came home that night covered in blood. He received a very long sentence. Story 18. The worst are those who think they are smarter than they are. When it comes time for depositions, broad, sweeping statements such as, "I would never allow discrimination in my office," and "I am 100% sure I never said that," are a great way to destroy your own credibility, set yourself up to be eviscerated by opposing counsel, and ultimately turn a nuisance value, frivolous case into a six-figure matter. Moral of the story: if you are going to ignore the entire day of deposition preparation I did with you just so you can protect your fragile ego on the record, at least do me the courtesy of telling me to get lost ahead of time. Story 19. It was a credit card fraud case early in my career. He actually wore the stolen clothes to court, and a clerk at the defrauded store identified them in front of the jury. I felt like the guy in the commercial who asks, "Want to be somewhere else?" Story 20. The client was charged with driving under the influence. He was forced by the police to provide a urine sample on the side of a busy interstate. Any sympathy the jury may have had was lost when he fell asleep while the traffic stop video was played. He had been out partying the night before trial. He was found guilty. He then lied to the judge about what would be in his system during a drug test, and his sentence was doubled. Story 21. Recently I was in court, and apparently part of this man's conditions was that he not contact his family. He called his mother on Mother's Day. The judge said, "Your mother seems to care about your freedom as little as you do. Put the cuffs on him." Edit. I do not know the parameters of this case. I was just a bystander in court. The lawyer, wearing sweats, said, "Oh, Judge, I told them, you can't fix stupid." It was wild to watch. Story 22. Not a lawyer. I was a legal clerk for a couple of years in college. It still baffles me that this one made it all the way to trial. A woman slipped and fell at a chain restaurant, claimed she had irreparably injured her back, and sought a large payout. She said she slipped on butter on the floor. On cross-examination, she was asked what type of butter it was. She answered that it was the little pats of butter they put out in the buffet. The defense immediately recalled the store manager. The store had never used that type of butter. The case ended pretty quickly. Laugh out loud. Story 23. I'm not a lawyer. I heard this from a man I used to work with. His brother-in-law was injured at work and sued for a sizable amount. The case seemed open and shut, and all the evidence favored his brother-in-law until he started talking. Asked to describe the day of the accident, he did fine until he reached the part about the equipment that injured him. He said there had been a note on it saying it was out of order, and that he discarded the note and started the malfunctioning equipment because he had a job to finish. That easy win was lost faster than the out-of-order sign. Story 24. I had a domestic violence case. For months, we attended preparatory hearings, gathered evidence, and obtained a restraining order. On the morning of the hearing, the person I represented told me she had gone on vacation with the defendant for a couple of weeks and had a good time. The opposing counsel then informed me he had substantial evidence that both parties had been enjoying themselves together. This does not mean abuse did not occur in the past, but it undermined our case, which relied mainly on testimonial evidence. I had to explain that, beyond the legal rules, a judge might view the claimant differently if presented with evidence that she had been socializing with the defendant, for whom a restraining order had been sought. We settled and avoided trial. Story 25. I used to work at a workers' compensation firm and saw people repeatedly injure themselves. Often they were doing tasks around the house, such as falling off ladders, using tools, or riding horses. When they were injured again, the insurance company was no longer liable. Many obtained doctor's notes stating they were fit to work so they could return to work because they were bored at home with a serious injury. They were then surprised when they no longer received workers' compensation and sometimes overexerted themselves, worsening injuries that had not healed. Story 26. This happened to a colleague. A wealthy client's son was arrested for selling drugs at a local music festival. The client bailed him out and hired his entire high-end law firm to defend him. The son shambled into the courtroom extremely intoxicated and loudly attempted to buy drugs from the bailiff. There was not much the lawyers could do after that. Story 27. I was in court once fighting a traffic ticket. A man's lawyer was pleading no contest to a charge he received for possessing a firearm while on probation. It sounded like the result would be additional probation and that the matter would be closed. Then the judge asked, "Do you have anything to say before we move forward?" The man replied, "I didn't know having a gun was against the rules. I had a gun, so I guess that makes me guilty." He smiled as if he'd stuck it to the system. The lawyer and the judge looked deeply disappointed. Story 28. I was defending a client accused of trademark infringement. He thought he knew better than the intellectual property attorney assigned to his case, me. So he posted on his company's website a message that effectively confessed to the conduct and claimed it was not illegal. He called the trademark owner a woke baby and told her to learn the law or get back in the kitchen and make her husband a sandwich. I wish I were joking. I was one email away from negotiating a settlement that would have allowed continued use of the complainant's mark with limited restrictions and a nominal fee. Needless to say, she saw his website, refused the offer, and took the case to court. My client lost badly. His lack of self-control cost him thousands of dollars. Story 29. I'm not a trial lawyer but a real estate lawyer. I had clients spend $15,000 on new lounge furniture and 4 televisions with their closing funds 48 hours before I was due to close for them. Story 30. I am a criminal defense lawyer. A client was arrested for driving under the influence. He lived in a small town. He and his wife would drive to the town's one bar, drink, then walk to their houseboat after a night at the bar, which was about 1/4 mile away. They knew everyone in the bar. Another patron they knew became very intoxicated, and the bar owner said she could not stay. The client and his wife walked her to his car, so she could remain there until her ride arrived. The client put her in the back seat of his sport utility vehicle. He was drunk, dropped the keys on the way to the front seat, opened the now unlocked front door, and turned on the car lights to see, because he had walked around to the front from the rear passenger side. Police often wait to see if people leave the bar while intoxicated. They saw the lights, said they saw driving, and immediately arrested him. The client had a prior driving under the influence conviction from about 12 years earlier. The judge agreed that it would not be admitted and the jury would not hear it unless the client opened the door. We could not win unless he testified. I prepared him thoroughly, but I told him under no circumstances to say he would never drive drunk or to discuss the past. Anything about the past must not be mentioned. The direct examination was going well, and I gave him an easy final question where he could explain the night and explain why he was upset about being arrested because he was not driving and thought he had done everything right. He said, "I would never do something like that." By saying that, he opened the door. The judge allowed the district attorney to introduce the prior driving under the influence conviction in rebuttal. The jury took about 25 minutes to convict. That is one of 100 stories. Life is never dull in the criminal defense world. Story 31. One of my brother-in-law's lawyers was described by his former client, who was on death row, as incompetent and as having failed to provide adequate counsel by not securing an acquittal. The client, who has since been executed, went to a nearby bar immediately after committing the murder at a grocery store in broad daylight and bragged for hours about how he had killed the victim in very specific detail. There were also more than a dozen eyewitnesses. Story 32. A foreign client had limited command of the local language. We sought to show that the client acted in good faith and was cooperative, and we asked the client not to contact the respondent directly. Despite our instructions, the client wrote multiple letters to the respondent in broken local language. Among other insults, the client called the respondent's attorney a cunning little whore, and the respondent submitted the letters to the court. Story 33. He sent a letter threatening to publish details of the dispute the day before mediation. The matter did not settle for anything close to his demands, and we had to accept a loss of $120,000 in fees. Story 34. I am not an attorney, but I served on the jury for a 3-defendant murder trial. We sat through weeks of testimony, and from the sheer amount of direct evidence the state had, it was extraordinarily obvious very early on that Defendant 1 had committed the crime. Defendant 2, Defendant 1's brother, and Defendant 3, Defendant 1's girlfriend were much less obvious, and the state asked us to consider circumstantial evidence that left most of us feeling like we had to make some leaps to reach the conclusion they wanted us to. That is, until Defendant 3 decided to take the stand. Defendant 3's lawyer did a very good job of painting her as the victim of abuse. Her lawyer had us feeling sorry for this poor, unintelligent woman who had been groomed since she was 16 by a man 20 years her senior. From that narrative, Defendant 3 was basically Defendant 1's slave. He controlled what she wore, what she did, and even who she talked to. He even forced her to get a tattoo that read Defendant 1's property. We saw texts about Defendant 1 killing Defendant 3's puppy because Defendant 3 had made him mad about something small. We saw texts from Defendant 3 to Defendant 1 cheering him on after he had sent her pictures of a bloody knife, the murder weapon, but her lawyer had us questioning if those words were just her playing the role of a supportive partner so he would not come after her. We were starting to believe she was terrified for her own safety, and that is why she did not report her boyfriend. Clearly this man was dangerous, and it seemed reasonable that she did not know how to escape him. Then the other defendant's lawyers and the district attorney tore her apart on cross-examination. They made her look argumentative, tripped her up in multiple lies, and by the time they were done, based on her own testimony, it was pretty clear that she did in fact know the victim and had been the one to plan the entire murder. We even started to feel like she probably manipulated Defendant 1 more than he manipulated her. The other defendants did not take the stand. When we went to deliberations, we all agreed it had been a bad idea for her to testify. We had decided Defendant 1 was guilty on all counts within the first 5 minutes. Defendant 3 was almost as quick. We decided that while she did not physically commit the murder, she had conspired and was just as culpable. Defendant 2 took the longest. We all felt strongly that he was somehow involved, but the district attorney had not met the burden of proof of beyond a reasonable doubt, so we had to return a not guilty verdict on all counts. For clarification, Defendant 1 and Defendant 3 were both found guilty on multiple counts. Defendant 2 was found not guilty. Story 35. I was a third-year law student in my law school's family law clinic. We handled a custody case that kept recurring. The husband remarried, and the stepmother wanted the biological mother out of their family, repeatedly dragging her to court over minor issues to try to obtain full custody instead of a 50-50 arrangement for her spirit son. We were in court every other month. The court consistently refused to change custody. Eventually, the stepmother accused our team of harming and threatening the child, called the law school, and demanded our expulsion or threatened to sue the university. We requested an emergency hearing, told the judge what had happened, asked for sanctions, and argued harassment. The judge found the couple in contempt for threatening us to influence the case. He questioned their ability to co-parent effectively and act in the child's best interests. The mother was awarded primary custody. The couple received every other weekend and some holidays. Given the couple's conduct, the judge barred them from filing further custody actions. Later we learned they had also filed a bar complaint against our professor, which was investigated and found to be without merit. Story 36. The client was accused of punching another man and knocking out a tooth. On the stand, he repeatedly said that he had arthritis and could not close his fist to form the punch described by the victim. Partway through his cross-examination, the magistrate stopped the proceedings to state on the record that he had watched my client clench his fist several times after making that claim. He was found guilty. Story 37. I am not a lawyer. I handle workers' compensation claims. This one always cracks me up. A man claims bilateral wrist injuries from repetitive motion caused by cutting meat. We get word when he posts on his Facebook about competing in a mixed martial arts event. We send surveillance, which shows him fighting with no apparent limitation. Story 38. During a custody case, my mother was extremely unstable and showed it when she was recorded saying she would drive her sport utility vehicle off the highest bridge in our city with the 3 children in the car. Days like that killed pieces of my soul. Story 39. Age discrimination case. The client said, age was never a factor. In a memorandum, the client wrote, he is just too old to be effective any longer. In deposition, the client said, age was a factor, yes. The case settled. Story 40. One of the first and only divorce cases I handled as a sole practitioner involved a man who said his wife had run back to Nepal and abandoned him and their 7-year-old daughter in the United States. He said he could not contact her and that she was likely with a new partner. We effected service by publication, filed everything with the court, and the case proceeded as uncontested until the wife returned, retained counsel, and showed that her husband had known where she was the whole time. He admitted to me by email that he had been deceptive. I told him that if he would be fully truthful going forward, we could work with the wife's attorney on an agreement, but his small retainer for an uncontested divorce was depleted, and he would need to pay more because it was now a contested matter. He did neither. I had no faith he would stop lying, so after telling him I could not represent him any longer, I filed a motion to withdraw as counsel, a mandatory withdrawal based on fraud, with the court. At the motion hearing, he stood up, objected, and said he did not want me to withdraw. He then tried to hand the court all of our communications. He had printed all of our emails. The wife's attorney told him they would see everything anyway, so handing them over was not a good idea. The judge was stunned. I explained that the withdrawal was mandatory and that providing any additional information would prejudice my soon-to-be former client. The judge briefly explained this to the client and granted my motion. He fell silent and I left. Story 41. I am not a lawyer, but I am a former police officer and spent a lot of time in courtrooms. One man was on trial for driving under the influence, and he wanted the judge to know that the officer who arrested him was just some punk kid. He insisted that he had only had 2 bottles of wine. His lawyer kept trying to get him to stop, but he continued to ramble. Eventually the judge said, I think you should take a moment to confer with your attorney. And the man replied, don't interrupt me. I'm not a child. The judge smiled, leaned back and said, "By all means, please continue." The defendant's attorney just looked like he was deflating. Story 42. I am not a lawyer but a forensic professional. This was not dumb. The client could not help himself. As Ron White said, he had the right to remain silent but not the ability. This was an involuntary commitment hearing for a very manic and psychotic man who had been hospitalized after trying to break into his mother's house by pounding on the door with a .357 Magnum. After the prosecutor spent a long time discussing diagnosis and mental illness, he rested his case, having literally forgotten to ask the doctor whether this man met the criteria for commitment. The defense attorney, with a surprised smile, was about to ask the judge to dismiss the case when his client tugged on his sleeve, and they had a heated, whispered conversation. The attorney informed the judge that his client was demanding to testify against his advice. After the attorney cautioned him that his testimony was not required, the man took the stand and launched into a rambling, angry tirade of disconnected, delusional thoughts until the judge stopped him. His last words were, "Oh, and Your Honor, make them give me my gun back." He was committed. Story 43. I'm not a lawyer. This isn't my story. The lawyer who handled my business matters and a legal dispute is a federal judge. Before he became a judge, he was a lawyer for divorces and civil cases. A wealthy male client filed for divorce. There's a prenup. It's pretty ironclad. It discusses the distribution of wealth. Alimony, if any, is laid out as a specific amount, increasing yearly based on inflation. There's one major exception. If you are caught cheating, defined as any sexual contact with a person before the divorce is final, you automatically get the worst terms of the prenup. In the woman's case, if she cheats, she gets zero alimony and a one-time payment of $100,000. In the man's case, if he cheats, he loses the main family home, all cars that are not his daily driver, and a quarter of his business. A buyout option is available, but it's not relevant to this story. The lawyer met his client in a conference room. The client was beaming. He shook the lawyer's hand and said, "Hey, Mike, I want you to meet Jasmine. I met her 2 months ago. She's amazing. We got engaged over the weekend in France." Mike shook her hand, slumped in his chair, and said, "We have a major problem. You are cheating on your wife with her, and legally this is discovery I am required to hand over to the other side." The client said, "How the hell am I cheating? We're separated." Mike said, "Cheating is any sexual contact before the divorce is final. It's in your prenup that you wrote yourself." The client became very angry and left, failing to appear in court. That resulted in a default judgment, meaning the wife got everything she asked for. Because of the cheating and the failure to appear, the judge ordered the transfer of money within 30 days as part of the initial agreement between the parties. The man was not there to contest it. He later tried to transfer the company to the new woman via a trust, but that was illegal. He also tried to hide money with her by giving her $1 million by bank transfer, but the judge stopped that once he found out and required the woman to repay the money since she had been given notice. He fought for years and ended up losing money, time, energy, his business, his house, 6 or 7 cars, and his new wife. Now, because I know his daughter from work, he is a retired, angry man living in rural New Mexico. He cannot afford to golf more than once a month, and he posts about how women are scum. Next morning edit. I certainly did not expect this to blow up. Thank you for the positive direct messages and replies. I'll try to reply if I see any questions in the thread to clarify things. Story 44. How much time do you have? I have hundreds of stories about clients making poor decisions. One particular client who comes to mind committed a series of burglaries while on electronic monitoring for another case. The state presented a list of his coordinates at his bond hearing. I argued that he was clearly not a flight risk because he kept his monitor on and that the court should release him on the same terms as his other case. The judge looked at me as if I were crazy and held my client without bond. Story 45. Not a lawyer, but my uncle used to be a prison manager at the local prison in the area of New Zealand where I grew up. They held internal court hearings when prisoners had broken the rules. The prisoners would appear before a couple of prison staff and explain, kind of like an internal hearing. My uncle acted as the judge for many of these hearings. One prisoner had been found with a cell phone. He denied repeatedly that it was his and said he did not know where it came from. My uncle asked him several times if he wanted to own up, but the man insisted it was not his. My uncle said, "Well, someone's wasted $100 on a phone then." The prisoner replied, "Fuck off. I paid $600 for that." I miss his work stories. Story 46. I am not a lawyer, but I had a case against a neighbor who built a fence on my property. He had a court order to move it and only moved it about 3 inches when it was supposed to move about 6 feet. On the stand, the judge said he must move the fence to the correct place within 7 days or be found in contempt of court, and that the rest of the charges would depend on his cooperation. The neighbor muttered under his breath that he was not moving the fence again. The judge immediately asked what he had said. The neighbor denied saying anything. He was found in contempt that day, had to pay a fine, and had to serve weekend jail for a month. He also lost the other cases. Story 47. Not a lawyer, but I watched as a girl in her early 20s giggled her way through sentencing on a petty theft charge. Instead of the same 30-day suspended sentence her remorseful-looking co-defendant received, she got 90 days in county jail. She was not giggling after that. Story 48. My client and I were in a meeting to have her child returned to her from foster care. They told her she needed to be careful about who she dates because the case involved domestic violence against her. She said she was not going to date anyone. They said that was unrealistic because she was young and likely to date. She then said she was not dating because she had returned to her former partner who had abused her. We walked into the meeting expecting to discuss schedules and left with them planning to terminate her parental rights. Story 49. Client in the interview with the police officer. I don't care how angry you are. You can't go around threatening to kill a 5-year-old. Client. I didn't threaten to kill her. I threatened her mother. He thought there was some sort of distinction there. We took a plea deal. Story 50. I am not a lawyer, but the local news repeatedly aired a clip from a murder trial in which the defendant took the stand against their lawyer's advice. The defense claimed self-defense. When the prosecution read transcripts of damning jail phone calls, the defendant, not the lawyer, objected. It threw everyone for a loop. The judge asked why he objected. He answered, "I did not know they would actually listen to my calls." A recess was granted, and when court resumed, he accepted a plea deal. Story 51. Not a lawyer. My dad's psychotic ex-girlfriend tried to press bogus charges against him and generally tried to ruin his life and career. She also made things up about me. We had to go through interviews at the detective's office and visits from Adult Protective Services. My dad and I filed protective orders. Her response to the protective orders, which I feared, was to vandalize part of his property in a gross and obscene way. She then returned to the detective and claimed I had stolen her non-prescribed drugs, effectively admitting she possessed illegal substances. As a result, she received jail time as well. Good riddance. Story 52. I am not going to badmouth my former clients, even ones who might deserve it. But my opposing counsel's client sued a debt collector for freezing my client's bank account without first obtaining a judgment against her. That is a major no-no in New York. The collector had been in the industry since before I was born, so I knew it was not an accident and suspected there was a reason he could not sue, which was why he acted. I thought we would likely settle cheaply because we could not prove anything beyond negligence. The collector produced the records for the underlying debt. One record looked clearly digitally altered, so I subpoenaed the creditor. Sure enough, he had changed the date of default to hide that the debt was time-barred, meaning he could not have filed a lawsuit about it. That would have been bad for him, but he still could have argued there was insufficient proof of intent. However, nothing implies intent like trying to cover it up. His attorney did not check discovery carefully enough, missed the alteration, and had to withdraw from the case because he had unintentionally aided perjury. It was a great result for my client and me. Moral of the story: if you do something wrong and get caught, trying to lie and cover it up usually causes much more trouble. Story 53. A friend was pursuing workers' compensation and suing the company for a few $1 million. He claimed he could not bend, raise his arms, or perform other movements. He took the stand using a cane. The lawyer asked him to read the highlighted parts of a local newspaper. The article said he had won a martial arts tournament a week earlier. The lawyer asked, "Can you explain that?" For the next 15 minutes he described each kick, punch, and takedown with a big smile. "I rest my case," the lawyer said. The jury foreman asked the judge whether they needed to leave the room or could simply announce the verdict. Story 54. I am not a lawyer, but I know a police officer who attended a report of a man being mugged. What did he steal? 275 pounds in cash and about 30 10-pound deals of crack and heroin. Really? Yeah, it was him. I have known him for years and he is a rival. The police officer wrote a statement detailing what happened and what was stolen. Sign here if that is correct and exactly what happened. The man signed. Thank you. You are under arrest for being involved in the supply of Class A drugs. The police officer charged the caller with possession with intent to supply, and charged the robber with robbery and possession with intent to supply. Story 55. I am a lawyer. I was cross-examining a slip-and-fall plaintiff on the stand at trial after 2 years of litigation. We were going over some pictures he had taken when he let slip that the picture of the two signs was missing. I grilled him on what he meant until the judge chastised me for trying to conduct discovery during trial, which is supposedly not allowed. He had clearly concealed evidence. We took a break, and the next day he came back with the photo in question, which showed that he had walked squarely between two wet floor signs to go down the Kroger aisle and immediately slipped and fell. He did not recover any money in that case despite the unfavorable venue. The judge who reprimanded me for exploring obvious evidence tampering was later appointed to the federal bench in Atlanta. Story 56. Oh, I can't believe I'm late to this party. I started at a new law firm that was in the middle of a long false advertising lawsuit. Our client, the defendant, maintained that their advertising claims were supported by a scientific report written years before that no one could find. The scientist who had run the tests said he remembered doing them but could not remember the results. The case progressed to trial, and at the close of the plaintiff's evidence, my client's chief financial officer burst into the federal courtroom holding a copy of the report he had found in the back of a cabinet he was cleaning out for who knows what reason. There was pandemonium. The plaintiff called for a mistrial. The judge banged his gavel, and the parties yelled at each other across the aisle. My boss objected into thin air, and no one listened. The report supported literally nothing in the advertising. It was great evidence for the plaintiff's case and confirmed everything they alleged in the complaint. We were hit for about $10 million in losses. I left the firm shortly after, in part because I was convinced that my boss and the chief executive officer had burned what they thought was every last copy. I still believe the chief financial officer kept one and did this on purpose because of a feud with the chief executive officer. Story 57. Is my client a perfect man? No. I killed him. Story 58. I was called for jury duty and sat in the courtroom, watching other potential jurors be questioned by the attorneys while I waited for my turn. One of the charges was aggravated assault. The defense asked one juror, a professional videographer, whether her career made her more or less likely to trust video footage. To me, this was a hint, not an admission, that video would be a major part of the case. Before the juror could answer, the defendant yelled from his table, "I had a mask on. You can't even see my face." The room went silent for about 5 seconds. The defense attorney regained his composure and asked the judge to dismiss the jury pool. The judge sent us back to the holding room. 5 minutes later, a court clerk returned and told everyone, including the already selected jurors, that the trial was being rescheduled and we were dismissed. Story 59. Not my client, but I watched someone admit in open court to solicitation of prostitution during allocution. The charge was statutory rape, which carries a mandatory minimum sentence in my state. The judge was already going to impose the minimum, so there was literally nothing the defendant could say to make the outcome any better. He elected to speak while his attorney slowly died at the table. He delivered a long speech about how the charge was unfair and would ruin his life and business, which was fairly typical. Then he said that he usually checks the ages of the sex workers and that this time he did not, and of course she was underage. The judge asked him to repeat it, and he repeated it verbatim while defense counsel just hung his head. The defendant was a character with many other eccentric habits and a colorful history that I learned about later. The judge was having a good day, so he imposed only the mandatory minimum, and I do not think the prosecutor's office pursued the additional charge. It was striking to watch someone talk himself into a much worse situation out of ego. Also, the number of people who show up to court for drug cases wearing marijuana and 420 shirts is astonishing. And the kids who used to steal TomTom devices and other global positioning system units from cars, then tell a sob story about wanting to go to law school but how these charges would ruin that chance, became a running joke at the courthouse. Story 60. Not a lawyer, but my ex totally ruined his custody case. The mother took off with the child and refused to return him in a state where that action would have led to even supervised visitation being taken away. When she finally sent the child for visitation, he had visible injuries inflicted by her boyfriend, and the child told his teacher at school, unprompted, that the boyfriend had hurt him. My ex's parents hired an attorney and obtained an ex parte order to keep the child. At the first hearing after that order, both parents were ordered to take drug tests before the next hearing. My ex had a history of marijuana use. His attorney told him he could get the next hearing pushed back by more than a month so he could be sure he would test clean, and my ex said not to worry. Then he used cocaine and failed the drug test. He did not show for court and refused to contact his attorney for months, until the attorney withdrew. The child was at the mother's for visitation when the results came back, so she was able to get an ex parte order to keep him. The reality was he did not want full responsibility for the child but refused to admit that to his parents. He deliberately blew the test and then claimed that because he worked in construction he must have been exposed to something that caused the failed result. I do not know whether his parents believed that. I had been with him for several years before I learned the whole story. He had previously told me he did not have money for an attorney to fight it, so he had just given her custody. I left him immediately after finding out the truth. It was bad enough that he did not want to be a full-time parent, but to do that when you knew your child was being abused was unforgivable. It helped me realize he was a sociopath. Story 61. She was doing magnet therapy with a therapist 5 hours away over the phone. The therapist had the magnets, and my client would hold the phone up to parts of her body that needed magnetic energy to help them heal. She paid $2,000 per month. She never told me about this during the dozens of hours we spent preparing. I learned about it during cross-examination by the other side. I had never been tempted to bang my head on the desk in court before. Story 62. Commit robbery to hire an expensive attorney with minimal experience in criminal law rather than accept a seasoned public defender. Story 63. Did anyone see the video of a man attending an online court hearing for driving without a license? He answered the call while he was driving. Story 64. I am a lawyer. I could write a book about this. Most mistakes happen when I am out of the office or in trial and cannot correct their behavior. Most common. Lying about easily verifiable, small things on the stand destroys credibility. For example, we know you did not pick your child up every single time from daycare because the daycare has a log and your mother signed the child out 50% of the time. We know you filed multiple restraining orders against your spouse because that is an electronic public record. Second most common. Changing your story on the stand. I prepare for facts to be the way you told me. I cannot prepare for facts I do not know about. Third most common. Completely ignoring advice. I told you that you could not take $150,000 out of the bank account without repercussions. Contempt proceedings followed. Order to sell the marital home. The home was actively for sale with a real estate agent. The client put a padlock on the house so no one could access it or sell it. Contempt followed. After 5 years, I finally obtained custody of the children for a client. When she went to pick them up, she brought a known violent felon, a loaded gun, and got in a physical fight with the guardian. I filed an emergency petition and the children were removed from her care. She had them for less than a week. She then called me a bad attorney in front of the judge because the children were removed. The judge laughed and informed her I had won the case for her until her own actions caused the reversal, and allowed me to withdraw on the spot. Story 65. The company wanted to save money on a federal patent infringement case and hired a family lawyer from the Yellow Pages. The lawyer was sanctioned by the court after missing multiple deadlines and mishandling discovery because he did not know how to handle such a case. The client lost the case. Story 66. My ex-wife, to save money, stopped meeting with her lawyer to prepare her custody case. The hearing was just the two lawyers and the judge, and my lawyer told me what happened. My lawyer presented our case, asking that the children remain in the same house with me instead of moving with my ex-wife. He described how well they were doing in school, their extracurricular activities and friends, that each child had a separate bedroom, and that my parents lived close enough to babysit when needed. The judge then asked my ex-wife's lawyer where she lived. The lawyer did not know. She knew my ex-wife had recently moved after being kicked out by the man she had been with, but she did not know the address. The judge shook his head and told them to prepare a custody and visitation plan he could sign. They accepted our proposal. I was awarded primary custody and my ex-wife received reasonable visitation. We did not want an every other weekend schedule because of the children's activities. Keep your lawyer informed. If you do not want to pay for a meeting, send an email. My ex-wife seemed to think she would get custody because she was their mother. That was her entire argument. Story 67. In an assault case, when the witness took the stand, the self-represented defendant screamed that the witness would lie, that there was no way the witness could have seen it, and that the witness had not been present when the defendant punched the victim. Story 68. My mother was in court as a witness in a case of criminal harassment between two of our neighbors. We knew the case was ridiculous and a sham. The accused neighbor was innocent and was being falsely accused by the local troublemakers, who kept provoking him and then wanted to sue him for easy money. By pure coincidence, the defendant was secular Jewish, like my parents. The two troublemakers who were also there were very angry to see my mother in court. One of them stood up and yelled that my mother was Jewish and only there because the defendant was Jewish, claiming that Jewish people always stick together to help each other. The judge immediately reprimanded him and dismissed the case. Thanks a bunch for sticking around till the end of the video. Remember to subscribe, and until next time, stay awesome and goodbye.